Welcome back. A big ruling came down last week on former President Donald Trump's election interference case in Georgia. A judge deciding that Trump and many others would be tried separately from two other defendants in the case. A blow to prosecutors, but apparently who wanted to keep everybody together. Let's bring in my guest today. She's a Georgia super lawyer and former Fulton County public defender, Chandelle Summer, up late with me tonight here on the Final Five. Welcome to the show. Good to see you.
Thank you. Nice to see you.
Let's talk about what we saw last week play out there in the courtroom, where things stand, and what sort of time constraints are we up against here?
Well, the parties are all subject to the court's whim when it comes to a trial date. Since they've all been indicted and arraigned, the court can set their trial date anytime they want. Two of the defendants, Kenneth Chesebro and Sidney Powell, have asked for a speedy trial, which under Georgia law means they have to be tried within 2 terms of court. In Fulton County, that translates to about 4 months from the date of the indictment. So that being the case, the district attorney's office, I think, was taken aback by that move. And so they tried to sort of counterpunch by saying, okay, we'll try them on October 23rd. Well, the rest of the defendants screamed and balked at that suggestion and said, we're not ready by October 23rd. That doesn't give us time to file motions or to do the kind of due diligence that's necessary in these types of cases. So the judge has agreed to sever all of the other defendants and just to try Chesebro and Powell on October 23rd, unless the defense counsel or the defendants that are remaining try to kind of pull a fast one and file speedy trial demands between October 23rd and November 3rd, which is the deadline for filing those speedy trial demands. So he required that they all waive their speedy trial demand rights prior to October 23rd, when they start the jury selection for Chesebro and Powell.
You know, with this monumental case that's going before the courts there in Fulton County, I mean, we rarely have somebody on the show who has the perspective that you do. When you look at the fact that you have tried cases before many of these courts, many of these judges, do you think that the court system in Fulton County is equipped or well equipped to handle these sort of cases?
Well, it's a big system. It's probably, one of the biggest in the state. But quite frankly, they're using tons of resources on this case that they could use for sort of the rank and file crimes that are out there. There's plenty of crime in Fulton County, but they're spending an inordinate amount of time, money, and energy on this case, which to me is a waste of resources because of the fact that they're doing basically the same thing up in Washington, D.C. Jack Smith has indicted former President Trump for the same conduct. So I think Fulton County has braced itself for this, but I don't believe that anyone anticipated that the trial would splinter into all of these separate trials. There's still the question of whether some of the defendants are going to have their cases removed to federal court. So that will leave just sort of pockets of defendants back in Fulton County if any of those cases are removed to federal court. So the resources of the district attorney's office are going to be strained by this case. And I, as a Fulton County taxpayer, I question whether it's really worth it.
So are there certain cases here, are there certain parts of the case, certain charges out there that you think maybe may not withhold the next couple of months of pressure, that maybe at some point Fani Willis might look at some of these cases and say maybe we should put our resources into perhaps focusing on, say, Trump or Sidney Powell as opposed to some of the other ones?
I believe that the lawyers, there's several lawyers who are indicted, and I think they have legitimate defenses, especially the first one who's going to trial on October 23rd. I think Kenneth Chesebro has a very strong argument that he was just giving legal advice to Trump. Sure. The idea that you submit alternate electors is not new. It's not something he came up with or dreamed up. It was done in 1960 in Hawaii. It also was done in 1876 during the Rutherford Hayes administration. There was a terribly disputed election, and they submitted alternate slates of electors in 4 different states during that administration. So this is nothing really new. And making an argument to a client that something is a possibility is a slippery slope when it comes to lawyering, because we do it every day in every city in America. Lawyers make suggestions and clients can take them or not. But to prosecute a lawyer for giving legal advice to me is questionable.
Does it fall under that whole idea of the First Amendment that we've heard used as a defense many times in these many different cases, where that's just it's a free speech right that you can say that sort of thing to a client? You can say that election was stolen even maybe when you knew it wasn't?
I think it falls within your First Amendment rights to have an opinion on